Now, on that note, it is not uncommon for them to have one. And then here's the other testable piece. That one trust account can hold almost all trust monies simultaneously. It can hold earnest monies. It can hold tenant security deposits. It can hold rent checks. All trust monies can be deposited in the same trust account. And it's not a big deal because we have very detailed ledgers of whose money is whose. However, very testable, potentially. The rule states that if you are managing any HOAs, you would have to have a separate trust account for every homeowners association you manage. You cannot mix those. So if a firm was managing 2 HOAs and also doing real estate sales transactions holding earnest monies, how many trust accounts at minimum would they need? 3. 1 for each of the HOAs and 1 to hold all the other trust monies. Everybody with me on that? Are they required to have trust accounts? No, but if that was the present situation, they would need to have at least 3 based on that. What you got, Raphael?
In case of HOAs, what's the reason behind it?
What's the law? I mean, it really is just written that way. I mean, I'm assuming because of the nature of how they're managed and how there can be, more litigation and confusion with HOAs. Maybe. I don't really know the reason. It's just the law. So, all monies can be mixed into the same trust account except for HOAs. Each individual HOA you're managing would have to have its own separate trust account. So don't you judge me like that, Anthony. Okay, listen. Okay, sometimes it just happens. I get a little excited. I talk a little too fast. Blah, blah, blah.
So basically, if you manage, like, I don't know, if you have 5 different HOAs, you have to have at least 6 accounts then.
Well, if you're solely managing 5 HOAs and you're not collecting any other earnest monies, you need 5 trust accounts. But if you're going to collect tenant security deposits and other trust monies, 6, because 1 for each individual HOA and a separate one for everything else. So here's a question to make sure you're tracking with me here. True or false? A real estate firm at Oak Island, North Carolina can have 1 trust account to hold earnest money deposits, security deposits, and collected rents. Yeah, no problem. We have dedicated ledgers. All of these are fine to be in the same trust accounts. So here's another very oddly specific rule dealing with trust accounts, folks. When we're dealing with trust monies, there is a very unique aspect to the depositing of them. Okay. When we are dealing with trust monies, we are supposed to deposit them in general within 3 banking days of receipt, meaning the day you received them in general. However, there is some differentiation when it comes to certain things. So if we're dealing with a tenant security deposit or an earnest money deposit, sometimes these are given as checks even before we formed a contract. We talked about this in the contract section, right? I said it used to be that we would give you an offer and we would hand you the due diligence check and the earnest money check at the same time. So that would be receipt of the earnest money check, the trust monies. But if a contract has not been formed, you can continue to hold that check until a contract forms if it's a check, right? And so you would have to deposit it within 3 banking days following acceptance. So if somebody submits an offer today, but you don't accept it today, 5 days later, you can still be holding that earnest money check. And then when you finally accept it, you need to deposit that earnest money within 3 days of contract acceptance. Same thing would be true of tenant security deposits with a proposed lease that may not have been accepted yet. So the general rule, I'll say it again, deposited within 3 banking days. However, if it's a check and a contract hasn't been formed yet, you can continue to hold it until contract acceptance. And at that point, you would need to deposit within 3 days of acceptance. Emphasis on if it's a check. And so this other note says that if it is cash, which can happen, if somebody was to give you $5,000 in cash as earnest money, we don't really like that. But if they were to do that, you do not follow that same exception, folks. Cash is too dangerous to just be sitting on somebody's desk. So even if we don't have acceptance, cash would need to be deposited within 3 banking days of receipt, with or without a contract. And it doesn't really matter because it's monies we're holding on behalf of others. If a contract never forms, we just pay it back to them. What you got, Brooks?
Does the way we receive the earnest money have to be the way that it is returned? So, like, say somebody hands it to you in like $100 bills, does that have to be how it is returned?
No, it could be wired, it could be written as a check, it could be any number of things. It doesn't have to be the same way, as long as they get the money back. Now, one word of caution, folks. You will get test questions sometimes that will say something along the lines of a provisional broker handling earnest money. When we're dealing with provisional brokers, the general thing that you have to understand is that if a provisional broker is ever given an earnest money check, they're not the ones depositing it. They're not the ones holding on to it. They can do none of that. They need to get it to their broker in charge immediately, is how you need to think of it. If a provisional broker is given an earnest money check, they need to deliver it to their broker in charge immediately. And their broker in charge would hold it and do with whatever it was appropriately. So if we ever give you a test question that says a broker or a provisional broker received a earnest money check, how long do they have to deposit it? They're not allowed to deposit it. If they get that check, they need to take it to who? Their BIC immediately. Careful. That will be one of the ones they try to trick you on the test. Occasionally. Sometimes. It does happen. What you got, Raphael?
What's immediately? It's like if you get it, like
It means there's no time frame associated with it. Take it there as soon as possible. Because like some things we say immediately, but in no case later than 3 days. This just says get it there as fast as possible. That's it. What you got, Bree?
When you're with a firm, is it more standard that all of the trust money is held through like a firm trust account and not a broker trust account? You know what I mean?
Yeah.
I wouldn't have my own trust account.
No. The firm has a trust account because remember, you have to be a BIC to have a trust account, and so the BIC of the office would have their own trust account.
Yeah.
No. Yeah. Another rule in regard to trust accounts, folks, is the documentation on the trust account has to contain the name trust or escrow account. That's true of the deposit slips, the checks, and the statements. All of them have to contain the name trust or escrow account by rule. And then we also said that you are dealing with a separate account. Cannot mix other people's money with your own. And so if you had your own money in there, that is called commingling. Very testable terminology that's highly illegal. It's prohibited. Get you in trouble. The exception is $100. Why? They say you can have up to $100 of your own money in that trust account to cover bank fees. That's it. So here's another part that can come up on the test. And Beverly said something about this earlier, but you are allowed to have interest-bearing trust accounts. That's legal. You just have to disclose to the parties that you're holding the money that they are interest-bearing and what's going to happen to the interest. So either you're going to disperse it as dividends to the people whose money it is, or you're going to keep it. Either way is legal as long as you tell them. And so if it is an interest-bearing trust account that is accumulating interest that you're going to keep, you would need to regularly remove that accrued interest so that you don't have over $100. Otherwise, it would be commingling. So let me ask you a question here. True or false? A buyer writes a $5,000 check to the Pericle Realty Trust account as her earnest money deposit. The non-provisional broker receiving the check must deposit the check within 3 banking days of receiving it. A little bit of confusion out there. Somebody tell me why they said what they said.
Because
The original broker doesn't deposit the check. The BIC has to deposit the check.
It's not a provisional broker.
It's a non-provisional brokerage, so that means they're a full broker, so they have the ability to deposit within 3 days.
There's one problem with that one, though.
Offer not a offers.
the big has to deposit.
Now you're onto something, Brad. Brad says no contract yet, folks. This says must deposit the check within 3 banking days of receiving it. There is no contract yet, so you don't have to deposit it within 3 days of receipt. Remember, we said you can continue to hold it until you actually have a contract. You can continue to hold it until you actually have a contract because it's a check. If it was cash, it would have to be deposited within 3 banking days of receipt, even without a contract. But you can hold the check until contract acceptance, and then you would have to deposit it within 3 banking days of the acceptance. Everybody okay with that clarification? And this is one of those questions that's trying to like throw you for a loop, because some of you thought it was provisional broker, even though it wasn't. Somebody's like, oh yeah, it's not provisional, so they can deposit it. But the question is really about timing. What you got, Antonia?
Okay, so quick question. So I know you said, basically, I feel like I'm getting confused with. Can you hear me?
Yeah.
Oh, I think my thing's off. Okay. I'm getting mixed up with the non-provisional and provisional brokers. So I want to make sure that I understand who can and cannot deposit.
You don't really need to think anybody can deposit it. Ultimately, we're going to give it to somebody who's responsible for it. And so it is going to be the custodian of the trust account that we're going to give it to. That's the person who's going to deposit it. So let's say that even as a full broker, I'm going to take it to my broker in charge as I get it. And they're going to be the ones depositing it. Don't get so caught up on that. Because we're not typically depositing it. We're taking it to somebody who is an employee of the broker who is doing it, or the BIC, who is going to deposit it on behalf of the BIC. Yeah.
Thank you.
Mm-hmm. Now, before I switch to the next slide, I'm going to ask you the question, because hopefully you remember this, folks. If we're holding trust monies, for example, an earnest money deposit. Okay, we're holding trust monies, for example, an earnest money deposit. If there is a dispute in regard to its disposition, what do we do? There you go, Brad. Hold on to it. That's the other option. So, folks, between Brad and Bridge, we got 2 different answers, and they're both accurate. So, when we're dealing with these, you would continue to hold it until you had a signed and written release by one of the parties to its disposition. Or if you got tired of holding it, you could, under General Statute 93A-12, deposit it with the appropriate clerk of court and inform them that they will now have to deal with the clerk of court. That is also an option. So either or. Continue to hold it until signed written release, or until Judge Judy tells us who to give it to, or if we get tired of holding it, we can turn it over to the appropriate clerk of court and say, y'all deal with them. Last couple notes here with trust accounts, folks. Obviously, when we're dealing with the retention of records rule, we said we have to retain all records in North Carolina for 3 years from the date of last activity. Piece of clarification, most of the time the date of last activity is closing the real estate transaction. However, if we were dealing with a situation where there is disputed monies and we finally disperse the disputed monies to somebody, that could be the date of last activity as well. So transaction was terminated, but we held the disputed monies for another 6 months, and we finally dispersed it. That would be the date of last activity, just so we're on the same page. Got another question for you, and I told you this one just a second ago, so hopefully you're good. Can a firm/BIC have an interest-bearing trust account? There you go. Sure they can. As long as we disclose it to the parties that it is an interest-bearing trust account and what will happen with the money. So I've already talked about some of this stuff earlier. Not so much this one, but the other one that's going to come up. But the limited non-resident commercial broker's license. Folks, remember I told you early on in this class, it is one of the rare things in this class that's exactly what it sounds like. It is limited. It is for people who do not live in North Carolina, and it is to transact commercial brokerage only. So they have to be actively licensed in another state, and they would have to apply for this. And what they would have to fill out is the declaration of affiliation and a brokerage cooperation agreement with the resident broker. And then, of course, apply for this license and get it. The North Carolina resident broker would be responsible for maintaining any trust monies, maintaining records, supervising them to make sure that they're in compliance with all North Carolina laws and rules. That's it. Now, if I was to ask you, well, better yet, let me ask you. Here's an example question dealing with this. Broker who is actively licensed in Minnesota may receive a limited non-resident commercial broker's license to participate in the purchase of an investment beach home in the Outer Banks. So this was the cautionary tale, folks, and this is why I hesitated. Do not confuse the word investment with the word commercial. Investment means it's to make you money. It doesn't make it a commercial property. Folks, 1 to 4 dwellings is residential. This is a 1 dwelling unit. It's residential. Does everybody understand this? So can you buy this with a limited non-resident commercial license, assist somebody in this transaction? No. It's not commercial. Commercial is 5 units or more. Anything 1 to 4 units is residential. Dirt and 5 units or more would be commercial. Got to be careful. So here's the slide I said. I couldn't remember where exactly it was or if it showed up. This is the licensing of business entities. Remember, a sole proprietor is a person operating independently with a broker's license. They never, ever, 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 ever have a firm license. A firm license is a licensed business entity. You create the entity with the Secretary of State. Folks, every single one of you can create an entity right now that has nothing to do with real estate. An LLC, which is a limited liability company, a partnership, or a corporation. All of those are acceptable for you to make right now. It's not doing with real estate. And then, of course, if you want your entity to do real estate transactions and or get paid for real estate transactions, it needs a license just like a people needs a license. And we call that firm license. So step 1, create the entity with the Secretary of State. Step 2, apply for and obtain a firm license from the Real Estate Commission. And you do that by being the qualifying broker, meaning the owner of the entity who is a full broker on active status, QB. And once you get a firm license, you now have a licensed business entity. And most firms will need a BIC, but not all firms need a BIC. What did I tell you? What firm, type of firm, does not need a BIC? There you go. An entity for compensation purposes only. It was created solely for the broker to get paid into it. Meaning it's not going to advertise, it's not going to have trust accounts, it's not going to affiliate other brokers. Ergo doesn't need a BIC. But most firms do need a BIC because most firms are intending to have trust accounts, affiliate other brokers, and advertise. Keller Williams, Coldwell Banker, Century 21, all of these firms have QBs, firm licenses, BICs, in order to do these different transactions. But just be very careful about the questions. Also remember that if we're giving you agency questions, a one-person firm can be a thing. So a one-person firm can't do designated dual agency, but it can do dual. A one-person sole proprietorship can't do designated dual agency, but it can do dual. A 5-person firm can do designated and dual, arguably, as long as they're not all PBs. Same thing with a 5-person sole proprietorship. So don't get so caught up. You got to make sure you pay attention to what the question's actually asking you about. So let me ask you a question here. True or false, North Carolina non-provisional broker wishes to start their own LLC for compensation and liability purposes. Once they have successfully registered their LLC with the Secretary of State, they may apply for a firm license with the North Carolina Real Estate Commission. I love the timing, Beverly. She's like, nope, not answering the question again. I just had a different question. This is true. A full broker on active status with an entity can apply for a firm license. This is a non-provisional. You got to be careful with that word non. Non is not provisional. It means full broker. Full broker creates an entity, can apply for a firm license. Full broker on active status is the only criteria to be the QB. Beverly, did you have a question from before?
Yep. Did you say that the question regarding commercial, typically a commercial property is like more than one? Was that like 5 or more?
It has to be 5 or more units simultaneously, or, has to meet other certain things. So if we're dealing with a single residential property up to a quadruplex, that's residential. But residential property in a capacity of 5 or more is commercial. And then, of course, if it's just an automatic commercial building, meaning not for dwelling, not for people living in or staying in, that would also be commercial. It doesn't have to be 5, but if it's a residential style property, then it would have to be at least 5 to be commercial.
Okay.
Yeah. What you got, Raphael?
It's just that I thought we didn't need to have register any LLC to have that.
To have what? The question is getting a firm license. That is a license for an entity. So the LLC would have to be created. The entity would have to be created before they could apply for the firm license.
Okay.
Yeah. Once again, do you have to do this? No. Can you create an LLC and get a firm license and do an entity for compensation purposes only as soon as you're a full broker, aka a non-provisional broker? The answer is yes.
So in order to have a firm license, you have to have an LLC.
You have to have an entity. Could be a corporation, could be a partnership. But you're not going to... The firm license is a license for an entity. You have to have an entity to get a firm license.
Okay.
Yeah. But if you're affiliating with a firm, your firm is going to have a firm license. You don't need one. We're talking about if you created the entity for compensation purposes only, you would need a firm license for that entity you created. But do you have to do this? No. So here's the other big conversations we had. Now I'm just going to put this all on the screen. We spent a decent amount of time talking about this, folks. When you're a real estate broker in North Carolina, there are the two big considerations, right? Your license, in order to play real estate, has to be active and current, okay? Active and current. And the way that you typically are active is through education. The way that you're typically current is through paying your renewal fees. Now, of course, it's a little bit more unique when you're a brand new broker, because when your license is issued, it is current for that licensing year at least, whatever left of it. But it's not active because you're a provisional broker, so you start out as inactive. But once you become a full broker, it's very consistent. You have to start taking CE, which stands for continuing education, starting when? Yeah, more specifically, right, and from a testable, it's in your second renewal period, okay? After your first renewal, or in other words, in your second renewal period. So for example, you folks, let's say that every single one of you get your license in December. Your license will be current from the rest of the licensing year, right? January through June 30th, because that's your license issuance year. And then you'll pay your renewal fees on June 30th of 2025. And then starting July 1, every single one of you is going to be in your second renewal year, the year leading up to your second renewal. And so every single one of you will need to take CE prior to June 10th of 2026. 2026. So it is after your first renewal year, or in other words, in your second renewal year, however you want to articulate it. But you have to pay your renewal fees every stinking year. Even though you all are going to get your licenses halfway through our licensing year, you will all have to pay $30 on June 30th of 2025. Folks, if your license was issued on May 30th, you'd still have to pay $30 on June 30th. They don't play around. They do not prorate it in any way, shape, and form. And if you get your license, if you take your test around June, they'll call you up and they say, we're not going to issue your license until July 1 unless you beg us. And then we're going to make you pay us both fees. Right. And so it's, that's just the way it works. So you're going to have lots of questions about current and active and expired. Now, remember the other thing too, folks. Expired is a standalone status. I'm going to get into that more in just a second. If you don't pay your dues, right? Currency keeps you current. Failure to pay expenses make you expired. If you don't pay your dues, you're just expired. Doesn't matter if you're good on education. Doesn't matter anything. Expired is always just a standalone status. If you ever see a test question that says expired and active, expired and inactive, don't you ever pick that. It's not a thing. Expired is just expired, just expired. Standalone always. The other combinations exist. You could be active and current. You could be inactive and current. But you cannot be anything other than expired when you hit that one. So active means in most circumstances you're good on your education. Of course, for a PB, that means you have a broker in charge. Inactive is what happens when you have an education deficiency. Oops, I missed CE. I'm going to go inactive. Oops, I missed my post-licensing. I'm going to go inactive. And remember, you cannot do anything on inactive status either. The only status that you can do any real estate on is active and current. Active and current. So, as a point of clarity, if you were to miss your CE, let's say you missed, one of these days won't be okay. If you missed your CE, which is questionable, by June 10th, your license will go inactive when?
June 30th?
July 1. June 30th, it's active until 11:59 p.m. on June 30th. And then as soon as midnight hits, as soon as it's July 1, you're inactive. So even though you missed your June 10th deadline, right? You cannot take CE after June 10th is hit. We have a blackout period. We can't teach it. So there's nothing you can do to stop from going inactive on July 1, but your license is active up to and including June 30th. Now remember what we told you too. They punish you. So if you miss your CE, let's say you missed all 8 hours, your 4 hours of update, your 4 hours of elective by June 10th, there's nothing you can do to stop from going inactive on July 1. And before you could reactivate, you've now got to take your New Year's update, 4 hours, your New Year's elective, 4 hours, and 8 hours of elective to make up for the 8 hours missed in the previous year. Because we do not teach the last year's update in the new year. It's gone. So you would have to have a total of 16 hours before you could reactivate your license. If you went 2 years without taking CE, folks, education can always be fixed. But they say it's not even worth doing that anymore. So they're going to make you take the New Year stuff plus 2 post-licensing classes as punishment to make up for all the class time missed. But you can always fix education. Just maybe a lot of classes. Now, expired is you failed to pay your renewal fee. Remember, renewal, currency keeps you current. Failure to pay expenses makes you expired. So you pay your $45 every year prior to June 30th. And if you do not pay by June 30th, on July 1, your license is expired. And it is only expired. Doesn't matter if you're good on your education. Standalone status. Now, they do punish you for expired as well. Folks, if you are expired for 1 day up to 6 months, it's automatically $90. And even after you pay the $90, you have to fill out Form 2.08 to reactivate and reaffiliate. If you were expired from 6 months up to 2 years, $90, new background check, reinstatement application, and you have to take the state licensing exam again as punishment, or you have to take a post-licensing class as punishment. It's no bueno. Janet says, where can you take your CE classes? With me, you silly goose. Teach all of them. You just may not want to join me. I don't know. After 80 hours, you may not want me anymore. It's fine. I get it. Yeah, we have all the CE classes too. And post-licensing, everything. Yep. So if you let your license go expired for more than 2 years, folks, you're back in this class. Don't do it. Pay the $45 every freaking year, folks. It don't make no sense. $45 to not have to sit through this class again? You best believe I'm getting out my checkbook every single year, right? If I was y'all, just swipe that card. 45. Listen, you spend more on that in coffee in 1 month. Pay it every year. What you got, Brooks?
If you remain current and over those 2 years, but you don't take your CE for those 2 years, are you still required? May it still potentially be a requirement to take the pre-licensing exam?
No. You can always fix education deficiencies just with a butt ton of classes, right? You may have to take... The exam was only ever a punishment for being expired for more than 6 months, but less than 2 years. They will only just make you take a crap ton of classes if you have an education deficiency. Folks, there have been some people, and I'm not kidding, they got their license, they used it for a while, they paid the dues every year, but they stopped taking classes for like 10 years. The commission doesn't make them take 600 hours of classes. They're still really just going to make you take 60 hours of post plus this year's CE. You can always fix education. Yeah. So understand too that when we're talking about licenses, we mean all of them, okay? If we were talking about a firm license, it expires at the end of the year, and so you'd have to pay a renewal fee on that. Your broker's license, the LNCL, all licenses expire at June 30th. And so for any license you have, you'd have to pay your renewal fees for it. So if you had the test question, as I asked you earlier, that said you had a firm license and a broker's license, how much is it going to cost you to renew every year? $90. $45 for each. Now, you do make those payments on the Real Estate Commission's website, ncrec.gov. No, they do not accept checks. They only take cards for convenience. And remember, you can pay as early as May 15th. That is the statutory period. You cannot pay any earlier than May 15th. So currency keeps you current. Failure to pay those expenses make you expired. And then active versus inactive typically deals with education, except in the case of a PB. So let me ask you a question. Better yet, you read it and answer it for me. Had a smattering of answers there to begin with. True or false, a North Carolina broker has not paid their $45 renewal fee for the past 2 years. To reinstate their license, they will need to complete the current year CE requirement and 60 hours of post-licensing. Folks, that is false. Well, it's not even just take the time. They have not paid their renewal fee for 2 years. That's back in this class. They are expired beyond repair. They're back in pre-licensing because they've been expired for more than 2 years. If it's 6 months up to 2 years, right, meaning under 2 years, it'd be the test and the reinstatement application and all that jazz. But 2 years means back in pre-licensing. Now, the next couple slides, Beverly says, does the Real Estate Commission send out reminders about upcoming dues? They send out emails. They used to send out a bunch of things in the actual snail mail, but it's costing them so much they decided to do away with that. So they will email you and say, don't forget to renew. And there's also a countdown timer on the Real Estate Commission website. And then, of course, your BICs help you figure it out. But let me throw another thing into the mix, folks. If you go expired or inactive and you are a BIC eligible broker, you lose your BIC status or your BIC eligibility, because the way they look at it is, if you're supposed to be supervising other people, but you couldn't even maintain your own license, we got some problems. And so can you get it back? Sure, as long as you still meet the criteria, and you may have to take the broker in charge course again if you haven't taken it within a year. That happened to me one time. It was embarrassing. It was when COVID happened. I was down at my house in Georgia. I didn't have internet or good phone service. I completely forgot that June 30th was coming up. So I got there in June, came back in July, and I had a nice notice from the Real Estate Commission that said, hey, stupid, didn't pay your renewal fee. Hope you didn't like your BIC status. You're back just to being a broker. And so I had to take the 12-hour broker in charge course again. 0 out of 5 stars, would not recommend taking the BIC class twice. Okay, I'm just going to put that out there. And of course, I had to pay the $90. It sucked. So, wrapping up the day, we have already talked about a lot of the prohibited acts, folks, and that is General Statute 93A-6. And so a lot of things that we discussed in the agency section came from there. Acting in a manner of unworthiness or incompetence to endanger the public, a provisional broker being paid by somebody other than their broker in charge, making false promises, making false advertisements of a character likely to influence, persuade, or induce, misrepresentations and omissions of material facts, a lot of different things. And these are all potentially testable. And we'll get into some more of them shortly, but we kind of talked about some already. So I'm not going to spend a whole lot of time there at the moment. I do want to bring something new into the mix to wrap up the night. I want to talk about the Real Estate Commission, folks. I keep talking about the Real Estate Commission. I keep referring to them, their website, their licensing, all these different things. If you were to call the number on the Real Estate Commission's website right here, right now, you're going to be talking to what we call a staff person, okay? The Real Estate Commission is actually 9 people. They're government-appointed people in a voluntary position. But before we get into that, I want to make sure you understand something. If you ever get a test question and the answer choice is, oh, the Real Estate Commission will reassign the contract. Oh, the Real Estate Commission will ensure that we get paid. Oh, the Real Estate Commission will ensure that the agent's protected. That's never going to be the answer. Ever, ever, ever. The Real Estate Commission is an enforcing and regulatory body, semi-governmental, governmental, whatever you want to call it, to help protect the public, not us, the public in real estate dealings. Yeah, you saw a question like that. That will never be the answer. They are not there to help us. They are there to help the public and protect them, arguably, from us, to make sure we know what we're doing so we don't endanger the public. And you're always going to answer the question that way. Now, when we talk about the composition of the Real Estate Commission, I told you they're voluntary members. There are 9 of them, but they are all government appointed. When we're dealing with the composition, though, there are certain rules. 3 of the members have to be real estate brokers at any given time, meaning licensed brokers. 2 of the members are not allowed to be involved in real estate, meaning not brokers. What are they typically? Attorneys, investors, bankers, a lot of different things, appraisers. They just can't be real estate brokers, more specifically. And the reason that is, folks, if you had nothing but 9 real estate brokers, they may be inclined to write rules that are maybe more favorable to real estate agents versus looking after the general public. So we like some diversification there. Now, what that means is 6 of them could arguably be brokers, as long as 2 are not. And of course, 5 of them, 6 of them, whatever it is, could not be, as long as 3 of them were. 6. So 3 members have to be brokers, 2 cannot at any given time. And the way that they are appointed, the governor of North Carolina picks 7 of them. So if you don't know the governor of North Carolina and or somebody on, a political aspect of things, you're not going to be a member of the Real Estate Commission. 7 are appointed by the governor. 1 is appointed by the Speaker of the House of Representatives of North Carolina, basically the head honcho of the Speaker of the House. and then the president pro tem of the Senate in North Carolina, the head honcho of the Senate. That's the composition. Now, they are 3-year terms, and they can have as many subsequent terms as they care to have. Now, when I say they're voluntary, they are paid for their work days, but they all have full-time jobs. So 3-year terms, can have subsequent terms. Other things that we've already mentioned about the Real Estate Commission, think about it this way, folks. The Real Estate Commission giveth and the Real Estate Commission taketh away. They are the licensing body that gives you your license. That is the seal of the North Carolina Real Estate Commission that you can barely see on the top of my license. So they approve real estate brokers. They approve real estate schools and educators. They, of course, work on education and informational resources for the public and for real estate brokers. They write laws and rules. They enforce them. They investigate unlicensed activity. All of these things. Now, I told you, the Real Estate Commission will never, ever, ever care about our financial commissions. You got to get that in your head right now. So if you ever have a test question that says, oh, they're going to make sure that we get paid. No, they aren't. That's not their thing. This one clarifying note at the bottom states that the National Association of Realtors does have an arbitration board for commission disputes, meaning commission disputes between brokers, not commission disputes between a broker and their firm or between clients and brokers. That would be civil court. So I don't think that's going to come up on the test. The other things we told you that they can do, folks, what did we tell you that the Real Estate Commission will never, ever, 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 ever do to a licensee as a punishment? There you go. Fines. No fines. But, another throwback question, who did we say that they will fine? Timeshare, specifically developers. Timeshare developers. Never brokers. Timeshare developers. Okay? Fines of $500 per violation of the North Carolina Timeshare Act. Remember that from like Unit 4 or whatever. So what do they do to us as brokers? Censure, reprimand, suspend, revoke, and limit. Censure and reprimand you can basically group together. It's in your record. You did something wrong. You got a slap on the wrist. It's in your record. They're not going to forget about it. Suspend your license, taking it for a period of time with the intention of giving it back. Revoking your license, they're not going to give it back, but you could potentially reapply for it after certain time frames have happened, depending on how long it was revoked for. Sometimes it's revoked for a period of time. Sometimes it's revoked indefinitely. And then, of course, limitations would be like, we'll let you keep your license, but you can't be a BIC for the next 2 years. Or we'll let you have your license, but you can't have a trust account for 3 years. Or we'll let you, something like that. They can put limitations on your license as well. So the enforcing body that they are. So let me ask you a question here. True or false, unlicensed person has been helping friends locate and negotiate properties for sale in Atlantic Beach, North Carolina. The North Carolina Real Estate Commission has the authority to investigate his activities and take further action if necessary. True. The Real Estate Commission has the authority to look into brokers and whether or not we did anything wrong and people holding themselves out as brokers. Now, thankfully, none of y'all fell into the trap of being like, well, what if there's no compensation? It's not what the question's about. We're just saying, can they investigate it? Yes. And if they investigate it and find there's no compensation, they're not going to do anything to them because they haven't violated any license laws or rules. But if this person is unlicensed, acting as a broker, getting compensated, they don't have the authority. It is actually a misdemeanor, folks. That's a violation of license law. The Real Estate Commission would have to actually pursue action through the Attorney General. They would have to have them file a cease and desist and potentially go through law enforcement if they wanted to go the way of an injunctionary relief. But typically it starts with a cease and desist letter. The Real Estate Commission cannot arrest people. They can investigate and then they can go from there. Yeah, whoop, whoop. folks, we are in a good place because really and truthfully, I've only got a few more slides of material, and then a lot of the back end of this is review stuff anyway. And that's what tomorrow is a review day. So I'm just going to, ask you some questions in the back of this. So the plan for tomorrow night is finish these review slides and then, of course, jump into anything and everything y'all want to talk about. So be thinking about it between now and tomorrow.